In the UK, understanding contracts and terms is essential for protecting your legal rights in both personal and business dealings. A contract is a legally binding agreement between two or more parties that outlines the terms and conditions of an arrangement. Whether you are entering into an employment contract, a service agreement, or making a purchase, it is important to understand the key elements that make a contract valid and what the terms mean in practice. A contract typically consists of three key components: offer, acceptance, and consideration. The offer is a proposal by one party to enter into an agreement, which must be accepted by the other party. Consideration refers to something of value being exchanged, such as money, services, or goods. Once these elements are agreed upon, the contract is binding, and both parties are legally obligated to fulfill their promises. In some cases, contracts can be verbal, but having a written contract is preferable as it provides clear evidence of the terms agreed upon, reducing the likelihood of disputes. The terms of a contract define the specific obligations, rights, and conditions each party must adhere to. These can include payment schedules, deadlines, responsibilities, and any contingencies. Understanding these terms is crucial because once you sign the contract, you are legally agreeing to them. If you fail to meet your obligations, you could be held liable for breach of contract. Conversely, if the other party does not fulfill their commitments, you have the right to seek legal remedies, such as damages or cancellation of the contract. It is important to carefully review the terms before signing, ensuring that you are clear on what is expected from both parties. In addition to the main terms of a contract, there are often standard terms that may be included, sometimes referred to as boilerplate clauses. These can cover matters such as dispute resolution, governing law, and contract termination. While they may seem standard, these clauses can significantly impact your rights and obligations, so it is important not to overlook them. For example, a governing law clause dictates which country's laws will apply if there is a dispute, while a dispute resolution clause may require you to pursue arbitration rather than taking the matter to court. It is also important to distinguish between express and implied terms. Express terms are those that are explicitly stated in the contract, either in writing or verbally. Implied terms, on the other hand, are not written, but are assumed to be part of the contract by law or custom. For example, in employment contracts, there is an implied term that the employer will provide a safe working environment, even if it is not explicitly stated. Similarly, when purchasing goods, the Consumer Rights Act 2015 implies that the products must be of satisfactory quality, fit for purpose, and as described regardless of whether the seller specifically mentions these conditions. When entering into any contract, it is advisable to read the entire document carefully. Pay particular attention to any clauses that limit liability, as these can restrict your ability to claim compensation if things go wrong. Look out for clauses that allow one party to make changes to the terms without the other party's consent, as this could put you at a disadvantage. If you are unsure about any part of the contract, seek legal advice before signing to ensure you fully understand your rights and obligations. Contracts may also include terms about how they can be terminated. This can happen in several ways, such as by mutual agreement, completion of the contract's objectives, or breach of contract by one of the parties. Understanding the conditions under which a contract can be terminated is important, especially in cases where early termination could result in penalties or other legal consequences. For instance, breaking a lease agreement before the end of the tenancy could result in losing your deposit or being liable for unpaid rent. In business contracts, terms related to intellectual property, confidentiality, and non-compete clauses are common. These clauses can have long-term implications, particularly if you are entering into partnerships or employment agreements. For example, a confidentiality clause may prevent you from sharing sensitive information about a company, even after you leave the organization. A non-compete clause may restrict you from working for competitors or starting a similar business for a specified period after your contract ends. It is important to be aware of these restrictions and negotiate terms that are reasonable and fair. When disputes arise, understanding the contract's terms is crucial for determining the appropriate course of action. If the contract includes a dispute resolution clause, you may be required to engage in mediation or arbitration before taking legal action. If the terms of the contract are unclear or ambiguous, the court will interpret the contract based on the ordinary meaning of the words used and the intentions of the parties at the time the contract was made. This is why having a clear, well-drafted contract is essential for avoiding disputes and protecting your interests. In summary, contracts are a fundamental part of everyday life, from employment to purchases to business dealings. Taking the time to understand the terms of a contract before signing can help you avoid legal pitfalls and ensure that your rights are protected. Always ensure that you are clear on your obligations, the obligations of the other party, and the consequences of not meeting those obligations. If in doubt, seeking professional legal advice is the best way to safeguard your interests and avoid costly mistakes. Understanding contracts empowers you to make informed decisions and ensures that your agreements are fair, transparent, and legally sound.